Morning, morning, John. Morning, Julie. And I'll ask Brian to introduce one of our new employees.
Yeah, thank you, Mr. Chair. Through you to the committee, I'm happy to introduce Marlene Bainbridge. She is our new administrative assistant, helping in engineering, planning, and enterprise. We're excited to have her join us. She's certainly already running in this position, and I'm sure in time we'll see future correspondence being delivered from her as well. And we thank her for her support as we continue forward.
Thank you. Welcome.
The church right there.
Okay, any requests for deferral of application requests for withdrawal, Mr. Chair, or Brian? There's none. Thank you. We have the adoption of the minutes from the last meeting. Are there any questions on the minutes?
I'll move it.
So moved. Moved by Dennis, seconded by John Andrews. Any questions? All in favor? Carried. Business arising out of the minutes? I don't believe there's any. Brian? Any pecuniary disclosure of pecuniary interest or general nature thereof? None declared. A business arising from correspondence? There isn't any. Any new business? None. So we go to the applications at 9:10. And we have with us today Mr. McComb. I was going to say Kevin, but I knew it wasn't Kevin. Sorry. And so our first one is at 9:10.
Through you, Mr. Chair.
Yes.
Ask why E922 moved from the agenda. It was on the pre-information package, but not on the.
I'd be happy. Give me one moment.
Okay.
Happy to. It was deferred at the request of the applicant's agent.
Okay.
Sorry.
Jim's fine. Staff report.
Yes. Especially county, municipality, and then the county just side. the time. So our first application is EA 20-22. Take notice an application has been made by Rodney and Trudy Malloy, 42595 Walnut Street, Union, Ontario, for consent pursuant to section 53 of the Planning Act as amended to sever lands municipally known as 42595 Walnut Street, Municipality of Central Elgin. The applicants propose to sever a parcel with a frontage of 18.11 meters, 59.42 feet along Stone Church Road by a depth of 111 meters, 364.17 feet, and an area of 0.20 hectares, 0.50 acres to create a new residential lot. The applicants are retaining 5.45 hectares, 13.47 acres, proposed to remain in residential use. Do we have any applicants or agents or interested parties who wish to speak to this application? Please introduce yourselves to the committee.
I think we've got somebody there.
Don't see anyone on there.
Rod Malloy.
Oh, Rod Malloy's on there, yes, no. Are you with us, Mr. Malloy?
Yes.
Thank you very much. I'll now ask Mark to go through some of the items on this application, please.
Certainly, thank you, Mr. Chair. Staff did review the application. There is a staff report with the agenda. In essence, the property requires rezoning as a condition from the municipality. It was noted from staff and county engineering, it's not on a county road. And the County Conservation Authority provided correspondence stating no concerns. The lot is outside of the regulated area. So staff completed a review, and our findings that the application is consistent with the 2020 provincial policy statement and complies with the county official plan and the Lower Tier official plan. It's staff's opinion the application is acceptable from a planning perspective and recommending approval subject to the following conditions. From the county, a digital copy of the draft and final deposited reference plan be provided to the County of Elgin. A solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County planning. Additional conditions recommended from the municipality of Central Elgin include approval of a zoning bylaw amendment to place a severed lot in an R1 zone. The applicant enter into an agreement with the municipality to address administrative, technical, and financial matters relative to the development of the subject lands. The payment of cash in lieu of the dedication of 5% of the land for parkland purposes, and a copy of the reference plan be provided to the municipality of Central Elgin.
All right, and we did have one question on it, is that right, Brian? One,
This application?
yeah,
No.
We had one piece of correspondence.
one correspondence. Did you send out yesterday? It came from
Opposing, yeah.
somebody opposed.
Oh, sorry, right, yes. There was a neighboring property owner that had submitted correspondence objecting to the application. They have listed, or had listed 3 items. Second. Number 1, the size of the lot does not meet the minimum width requirement, was their first concern. Number 2, the applicant submitted an agreement in March of 2016 stating only one single detached dwelling, which is bylaw 1996. And number 3, as per the staff report, the applicant used the entry to create an unfenced pond in which the current entrance can be used by emergency vehicles to access the unfenced water feature. The applicant is able to service the pond as well as emergency access to the back of their property and adjacent properties.
you have any? Yes, go ahead, Mark.
Thank you, Mr. Chair. Just a couple of comments.
Yes.
For the committee. As far as the size of the lot is concerned, whereas the frontage doesn't meet the R1 standard for an unserviced lot, which would be 30 meters, it would meet for a service lot, which is 15. However, staff reviewed this. I mean, it may not meet the frontage standard, but it exceeds the depth standard and has more than enough lot area to handle private servicing on this proposed lot.
Okay.
With respect to the second point on an agreement, there's no agreement. It was simply a zoning bylaw amendment that was passed at the time that the current house was built. And that amendment specifies one house on the lot, but the zoning is proposed to be changed for this proposed lot. It'll become an R1 variation, so an R1 dash something that will address the deficient lot frontage. And as far as the emergency access, I mean, emergency services for Central Elgin would have been circulated the consent application for comments. And I'm sure if they had any concerns about access to the site, they would have noted at that time, but we have nothing from them.
Any questions from any of the members? Moved by John Andrews, seconded by Rosemary. Any comments from anybody else?
Yeah, Mr. Chair.
Yes, John?
Yes, it may be a small point, but is this, the CEOP appears to indicate this is a tier 2 area. But unless I'm reading the material incorrectly, it didn't seem like there were even partial services. Have I missed something here? Is this a tier 2?
Go ahead, Mark.
It is a tier 2, but the municipality of Central Elgin has completed a class environmental assessment for bringing full services into Union. And it was noted by the Director of Asset Management with the municipality of Central Elgin that is in fact going to be the case. So at some point in the future, there will be full services brought into Union, which will elevate its status to a tier 1. So that will change at some point in the future. The municipality did request a development agreement be entered into, and I'm sure that as a part of that agreement, the municipality is going to look to have some sort of clause that will require that they hook up to full services once those are available at the lot.
So you're okay with the way it's been designated then?
Yes, we are.
Thanks so much.
Any other questions? We have it moved and seconded.
Mr. Malloy have any comments?
Mr. Moy, do you have any comment? Pardon? Did you have a comment? Mr. Moy?
No.
Thank you very much. I'll call the vote. All in favor? Yes. The decision rendered today for this application will be circulated within 15 days after the notice. There's a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. And our next one's at 9:20.
I don't think you can move that far.
Really?
Move it down.
Our next application is E10-22. Take notice that an application was made by Mark Curley, 9590 Curry Road, Wallacestown, for consent pursuant to section 53 of the Planning Act 1990, as amended to sever lands municipally known as 9590 Curry Road, municipality of Dutton Dunwich. The applicants propose to sever a parcel with a frontage of 25.15 meters, 82.51 feet along St. Andrew Street by a depth of 35.81 meters, 117.9 feet, an area of 0.81 hectares, 0.22 acres, to create a residential lot. The applicants are retaining 0.81 hectares, 0.22 acres, containing a residence and a shed, proposed to remain in residential use. Do we have any applicants or agents or interested parties who wish to speak to this application? Please introduce themselves to the committee.
Yes. Hi, Mr. Chair. This is Mark Corelli. I'm present for this meeting.
Thank you very much, Mark. I'll now call on Mark Coombs to go through the reports from the municipality and the Central Elgin.
Thank you, Mr. Chair. As a result of circulation of the application, we did have correspondence come in from the municipality, essentially supporting the application subject to a number of conditions, which I'll go through in a minute. County engineering indicated that the property is located on a county road and have a series of conditions as well that they are recommending. Lower Thames Conservation Authority circulated and indicated no concerns with a separate letter. So staff went through and did an analysis of the application. There's a staff report with your agenda package. The recommendation from staff is that the application is consistent with the 2020 provincial policy statement and complies with the County of Elgin official plan and the Dutton Dunwich official plan regarding lot creation and settlement areas. As such, staff is of the opinion the application is acceptable from a planning perspective. We are recommending approval subject to the following conditions. From the county, a digital copy of the draft and final deposited reference plan be provided to the County of Elgin. A solicitor undertaking to provide a copy of a registered deed for the severed parcel once completed. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County planning. That the owner dedicate lands along the frontage of the severed lot parcel up to 15 meters from the center line of the construction of Curry Road, County Road 8, to the County of Elgin for the purposes of road widening if the right-of-ways is not already to that width, to the satisfaction of the county engineer. All costs to be borne by the owner. Direct connection to a legal outlet for the severed lot is required if an existing connection is available, to the satisfaction of the county engineer. All costs by the owner. Discharge of water to the county road allowance is prohibited. That if necessary, an entrance permit be obtained from Elgin County for a new entrance to the severed and or retained parcels. All costs associated with this shall be borne by the owner, and a lot grading plan is required for the severed lot. Additionally, we have comments recommended from the municipality of Dutton Dunwich, those being that a minor variance application is in force in effect for the severed and retained parcels, and that is with respect to what they identified as deficient lot area for the lots. That septic system review for the severed parcel has been completed. That municipal drain reapportionments have been completed. That a mutual drainage agreement under Section 2 of the Drainage Act has been provided to provide a legal drainage outlet for the newly created residential lot. That 2 hard copies and 1 digital copy of the registered survey have been provided to the municipality. Taxes are to be paid in full. That a new 911 number be established for the severed and retained parcels. that all Dutton Dunwich planning application fees set out in the fees bylaw be paid to the municipality. Proof of water service to the satisfaction of the municipality. Proof of access to the satisfaction of the municipality. The parkland fee be paid for the new residential lot. That the solicitor provides an undertaking that the copy of the registered deed for the severed parcel, once the transaction has occurred, will be provided to the municipality. That a lot grading plan be provided to the satisfaction of the municipal CBO. And that proof of septic system design be provided to the municipality subject to CBO approval. Those are the recommended conditions.
Thank you. Any of the members have any comments? Any comment? Yes, Jack, you have a comment?
Well, I was just trying to go back to the original application. Correspondence from Mr. Clutterbuck. He had noted in here somewhere that there was a discrepancy on the measurements. Was that addressed? Here it is. So Brent Clutterbuck, drainage superintendent, said that he did some math on the lot sizes and it didn't make sense, what the numbers that were in the application. Just wondered if that should be addressed. It's on page 40 of our package. In reviewing the notice, I did some math. The lot sizes don't make sense. It states 0.81 hectares, 0.22 acres, but 0.81 hectares equals 2 acres actually. So I wonder if for legalities, we should note that because the application lot sizes doesn't make sense. What do you think, Brian?
We can certainly
Note it,
note that the correction be clarified.
if assuming his math is correct, yeah.
Yes.
But 8.81 hectares is actually closer to 2 acres, not 0.22.
Yeah.
Yes.
Mr. Chair.
Yes, go ahead.
I mean, it will require a reference plan be created for the lots. And so the surveyor at the time that they create the reference plan will be able to confirm those measurements.
Okay, so we shouldn't have to do anything with this.
I mean, I'm not sure what the exact tolerance is permitted by the committee in terms of a difference between the reference plan and what they submit the application, but as long as the applicant is pretty sure that those measurements are accurate, it will certainly be confirmed at the time of the reference plan creation.
And you have any questions from the applicant?
Hi, Mr. Chair. Yeah, just in regards to that letter that was just referenced, that was an error in the first notice that was sent out to.
We lost.
Yeah, through Mr. Chair, the applicant did.
Regarding the zoning, it had stated in it that the zoning was agricultural. It had also stated incorrectly where the highway runs along the frontage of the two new severed lots. There was also another, it was not correct in another way, and so I brought that forward to Brian, and he made a correction of that and sent that out. So I believe that's an outdated letter there, and that's why that confusion there.
Okay. Yes, Brian, you have a comment?
Through Mr. Chair, further to Mark's comments, some discrepancies in original application submitted were noted to Mark. Mark adjusted or made the required adjustments and submitted a revised application. So Mr. Clutterbuck's correspondence relates to the original application.
Okay. Thank you very much.
I'll move the recommendation.
Moved by Dennis, seconded by Doug Alderson. All in favor? Carried. The decision rendered today for this application will be circulated within 15 days after the notice. There's a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any conditions imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. A copy of the comment package is also available upon request. Thank you. Our next application is E11-22. Take notice that an application is made by David and Mary Thiessen, 51631 Carlton Line, Aylmer, for consent pursuant to Section 53 of the Planning Act 1990 as amended to sever lands municipally known as 51553 Carlton Line, Township of Malahide. The applicants propose to sever a parcel with a frontage of 12.0 meters, 39.37 feet along Carlton Line by a depth of 239.0 meters, 784.12 feet, and an area of 2.91 hectares, 7.2 acres, to be conveyed to the adjacent property. The applicants are retaining 35.61 hectares, 88.0 acres, proposed to remain in agricultural use. Do we have any applicants or agents or interested parties who wish to speak to this application? Please introduce yourself. Dave Rowe.
Mr. Rowe, I think you're muted.
Are you with us, Mr. Rowe?
Yes, I am.
Thank you. I'll now call on Mark to proceed with the comments.
Thank you, Mr. Chair. It's noted in the planning report that these lands were the subject of an official plan amendment. We have to have an amendment approved, and it was approved by the county for the proposed use for the severed parcel. The zoning amendment has been deferred until the OPA 19 was finally approved and this consent is granted, but they are prepared to deal with that. Circulation of the application resulted in county engineering having no comments and the Catfish Creek Conservation Authority also having no comments on the application. So there is a staff report noting that the application is consistent, in our opinion, with both the 2020 provincial policy statement, and it complies with the County of Elgin and the Township of Malahide official plans, the Malahide official plan as amended. Subject to the applicant obtaining a zoning bylaw amendment and entering into a site plan agreement with the township. Planning staff are of the opinion the application is supportable from a planning perspective and recommends approval, subject to the following conditions. From the county, a digital copy of the draft and final deposited reference plan be provided to the County of Elgin. The severed land be merged in title with the abutting lot legally described as part of Lot 24, Concession 3, municipally known as 51631 Carlton Line, and the solicitor undertaking whereby they inform the committee in writing that the lands are being conveyed to an abutting property owner and thus a merger of title will take place, which merger shall include all interest held inclusive of mortgagee's interest. Additionally, it's recommended that the following conditions from the Township of Malahide be included: that the applicant initiate and assume, if required, all engineering costs associated with the preparation of a revised assessment schedule in accordance with the Drainage Act, RSO 1990 as amended, with a deposit to be paid in full to the township prior to the condition being deemed fulfilled. If the deposit does not cover the cost of the revised assessment schedule, the applicant will be billed for any additional costs incurred. That the applicants initiate and assume all planning costs associated with the required zoning amendment or other land use planning processes as required in accordance with the Ontario Planning Act, RSO 1990, with such costs be paid in full to the township, and that the required process be successfully completed prior to the condition being deemed fulfilled. That all outstanding work orders or bylaw enforcement issues be resolved to the satisfaction of the chief building official prior to the condition being deemed fulfilled. That the necessary deeds, transfers, and charges for certificates and or instruments necessary for registration be submitted in triplicate prior to certification, all of which are to be fully executed. That all applicable property taxes, municipal fees, and charges be paid to the municipality prior to the stamping of the deeds. And that an electronic version of the reference plan be submitted to the satisfaction of the municipality.
Thank you. Any comments from any of the committee members? Any
Chair?
comment? Yes. John Selden, yes.
Through you, Mr. Chair, to David Rowe, to Mr. Rowe, was the OPA instituted so that the M3 designation of uses of the land could be modified to accommodate the use for the creative enterprises? Was that the purpose of the OPA?
Well, yeah, first of all, the OPA was actually required because it's the expansion of a non-agriculturally related industry. That was the main reason. The zoning is, again, site-specific to permit the proposed use, which is the manufacture of drums used for mixing and concrete and that type of thing. So it was a site-specific, both official plan amendment and the zoning bylaw will be a site-specific bylaw as well.
Thank you.
Any other questions?
Move it.
Moved by Rosemary, second by John Andrews. All in favor? Carried.
Thank you.
The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of the decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at algon.ca. A copy of the comment package is also available upon request. Thank you. Mark, we'll do these two separately. Jim, I mean, oh, sorry, yes.
Careful, because you never know if he's gonna put in the file.
Fall or whatever.
No, he's coming along quick. Okay. See that,
Cards.
Yeah.
just getting in the swing of things.
Okay, we'll now do application E71-21. An application, take notes, an application has been made by Barbara Farms Incorporated, 33812 Fingal Line, Fingal, Ontario, for consent pursuant to section 53 of the Planning Act 1990, as amended to sever lands municipally known as 11714 Coyne Road, municipality of Dutton Dunwich. The applicants propose to sever a parcel with a frontage of 64 meters, 209.974 feet along Coyne Road by a depth of 106 meters, 347.769 feet, and an area of 0.68 hectares, 1.68 acres, containing one residence, one small drive shed, surplus to the needs of the purchasing farmer. The applicants are retaining 40 hectares, 98.84 acres, proposed to remain in agricultural use. Do any applicants or agents or interested parties who wish to speak to this application, please introduce yourself to the committee.
Herman Lansing.
Thank you, Herman. I'll now call on Jim to proceed with comments from the municipality and the county.
Thank you, Mr. Chair. This application and the following application, the next one that the committee is dealing with, both came before the committee in 2021, but were deferred because the applicant at the time was the purchaser, and under the rules, under the Planning Act at the time, that wasn't permitted. But under the knowledge that that was about to change, the applications are simply deferred. So with those changes, the applications now can proceed. And so through the circulation, the municipality of Dutton Dunwich is recommending approval subject to the conditions they've provided. County engineering indicated the application is not on a county road. And the Lower Thames Valley Conservation Authority indicated or has provided no correspondence. So we have the staff planning report on the agenda. Recommendation notes that the application was originally deferred by the committee as it was considered not consistent with either the provincial policy statement of the County of Elgin official plan regarding lot creation of surplus dwellings, since the dwelling was surplus to the needs of the purchasing farmer. Changes to the Planning Act brought about with the proclamation of Bill 276 on January 1st, 2022 now allow purchasers under an agreement of purchase and sale to apply for the consent. Staff are of the opinion the application can now be considered. It's consistent with the PPS and the county official plan. And should the Land Division Committee support the application, the following conditions are recommended by Elgin County. Digital copy of the draft and final deposited reference plan be provided to the County of Elgin. Solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of Elgin County planning. And it's also recommended the following conditions from the municipality of Dutton Dunwich be included as conditions for the consent if supported. That a zoning bylaw amendment is in force and effect for the severed and retained parcels. That a septic system review for the severed parcels has been completed. That municipal drain reapportionments have been completed. That a mutual drainage agreement under Section 2 of the Drainage Act has been provided to provide a legal drainage outlet for the newly created residential lot. 2 hard copies and 1 digital copy of the registered survey have been provided to the municipality. That taxes are to be paid in full. That a 911 sign be established for the severed and retained parcels. That all Dutton Dunwich planning application fees as set out in the fee bylaw be paid to the municipality. That the solicitor provides an undertaking that a copy of the registered deed for the severed parcel once the transaction has occurred will be provided to the municipality. And that all barns capable of holding livestock or are in disrepair on both the retained and severed lands be removed or decommissioned to the satisfaction of the chief building official.
Thank you. Any other comments from any of the members of the committee? No comments? Any comments, Mr. Lansing?
I don't. I was here in October.
Move the recommendation.
Moved by Dennis, seconded by Doug Aldred. All in favor? It's carried. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent comes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for the certification, or the consent will be lapsed and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. A copy of the comment package is also available upon request. Thank you. So that was, gotta wait for the time. We got about 3 or 4 minutes yet before we can do the next one.
Mr. Chair, if I may address the committee, it's Mark Coombs, who was supposed to attend this meeting as agent on behalf of the applicants in the first matter today. Unfortunately, we have lost power in Talbotville, and so my internet has gone out. And I'm just trying to jury-rig myself into the meeting on my phone at the moment. I just wanted to ensure that there were no issues that the committee needed addressed in that application, and if there were, if I may be able to reopen that agenda item to speak to it now.
That was the one for Trudy Malloy.
Correct, that was the Malloy application.
Moyla. Yeah, no, it was, and I'll ask Jim, Jim to speak to that, but there was no questions for Brian. There was no questions on.
No, there was, it was noted, Mark, that we had one piece of correspondence come in, an objection from a neighbor. But
Okay.
Staff did review there's about 3 points on that letter of objection, and staff did review those with the committee. The committee decided ultimately to approve the application subject to the conditions that were recommended by the county and the municipality of Central Oakland.
Okay,
Okay,
thank you for that.
you're welcome. Thank you.
Okay. Much appreciated, thanks. Thank you, Mr. Chair, and thank you, members of the committee.
Thanks. I knew there was something. It's now time for the next application, which is E72-21. Take notice that an application has been made by Barbara Farms Incorporated, 33812 Fingal Line, for consent pursuant to Section 53 of the Planning Act, as amended to sever lands municipally known as 11552 Coyne Road. The municipality of Dunwich. The applicants propose to sever a parcel with a frontage of 30 meters, 98.42 feet along Coyne Road by a depth of 172 meters, 564.30 feet, an area of 0.70 hectares, 1.72 acres, containing one residence, one small shed, and a barn, surplus to the needs of the purchasing farmer. The applicants are retaining 40 hectares, 98.84 acres proposed to remain in agricultural use. And applicants or agents and interested parties wish to speak to this application, please introduce yourself. And we have Mr. Lansing with us again, and I'll ask Jim to comment on this again, please.
Thank you, Mr. Chair. I guess my most succinct comment could be ditto. The reports from this one and the last one are essentially identical. Same comments from county engineering, the Conservation Authority, and the local municipality. And if you like, I can read through the conditions, but they're identical to E71.
Is there any questions of any of the members?
I'm in agreement with that.
Any other questions? Moved by John Andrews, seconded by Doug Aldred. All in favor? Carried. A decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. A copy of the comment package is also available upon request.
Thank you, gentlemen
Thank you.
and ladies.
Thank you. So now our next one starts at 10. If you want a 5.
Sure.
I'll now ask Brian to introduce the two lawyers to us for today.
Through Mr. Chair, representing the county, we have both Mr. Hogan, our external legal counsel, as well as internal senior legal counsel, Nicholas Loeb. And I also believe we have Lisa Govesi, if you can just confirm you're with us as well.
Good morning. Yes, Lisa Gilvesi, and with me is also Greg Mitchell and Scott Gilvesi.
Thank you very much. So we're going to have comments first, Brian.
As it relates to this application, we'll give Lisa, Greg, or Scott the opportunity to speak.
Okay.
And then I have Mr. Loeb. He'll present a staff report, and then we'll open it up to the committee for any questions.
I'm sorry, I may have missed part of that. I was hard to hear, sorry.
Who was that?
That's Lisa.
Okay, I'm just looking for getting ready to start on this. Where are we here? The applications, are they on here?
122, I think it starts here.
Oh, the application, I got E7621. They're all the same, were they?
Pretty much.
I've got application E76-21. The decision was made in the matter of an application for consent pursuant to section 53 of the Planning Act as amended as it affects the following property. Concession 8, part of lot 22, plan 258, and part of lot 11. The applicants proposed to sever a parcel of the frontage of 26.33 meters, 86.38 feet by a depth of 14.59 meters, 133.16 feet, and an area of 0.10 hectares, 0.25 acres for future residential use. The consent was requested by Greg Mitchell and Scott Gilvasi, and the consent granted to Greg Mitchell and Scott Gilvasi. And I understand now that it's now in a numbered company, and I'll ask the lawyers to speak to that, our lawyers, the county lawyers.
Start with Lisa first.
Start with Lisa.
Okay, I'll start with you, Lisa, then, please.
Good morning. I had sent a letter in yesterday with some attachments. I'm not sure if everyone got that, but the gist of it is that the property was acquired in May of last year by 1128 Properties, Inc. It continues to be owned by 1128 Properties, Inc. There's been no change of ownership. The principal of 1128 is Mr. Mitchell. He was one of the applicants, and he is the president and sole signing authority on 1128. And I believe by inadvertence, the application was submitted by Greg and Scott as they are working together on the development of this project. And for some reason, I did not see it until the notice of decision had been issued. And I'm not sure why the ownership issue wasn't caught before, but in any event, the proper person to have signed would have been Greg Mitchell. He is a signatory to the applications and has been involved all along. And we're seeking the committee's consent or amendment to the 4 applications so that the certificates can be issued in the name of 1128 Properties, Inc.
I'll now ask the county lawyers to speak to it.
Good morning, I'm Nicholas Loeb, I'm senior counsel with the county, and so the issue that's sort of presented to you is the Planning Act contemplates that an owner or their authorized agent has to make the application, and in this instance, Mr. Mitchell signed it, and the way it appears in the application looks as though he did so in his sort of personal capacity as the individual Greg Mitchell. The property is actually owned by his corporate entity, 1128 Properties, Inc. And so the issue that has just been described that was just sort of done through inadvertence is the application isn't from the owner. However, this is sort of a fairly unique circumstance in terms of the corporate entity sole principal, which is included in the materials that were forwarded this morning, is Mr. Mitchell anyway. So ultimately, a reasonable legal solution is to just certify the deeds in the name of 1128 Properties, Inc., notwithstanding it wasn't as clear as we'd like it to be on the original application, because the intent of the Planning Act there is to make sure that an owner is the one making an applicant or someone on behalf of the owner, so that it's not someone who doesn't have an interest in the property making the application. So I think the proposal that's been presented is a legally defensible one and a reasonable one to make. However, it's being brought to you for your consideration to make sure you're satisfied with that, because the Secretary Treasurer doesn't have delegated authority to make that decision herself and then certify the deed. So that's the situation before you. I agree that the intention of the Planning Act regarding an owner making an application. Now that we have the proof that Mr. Mitchell is the principal of 1128 Properties Inc., this is a reasonable solution. It's a bit different than the normal issues of ownership that would come before you. So those are my comments, and if Mr. Hogan hasn't yet, invite him to make any, but.
Just a couple of quick comments. Having reviewed the applications, there doesn't appear to be any breach of any planning concerns with this application. The only concern, of course, is procedural, administrative signing of the application. In other words, there was no precondition as to the type of person, such as a surplus farm dweller, having to be a farmer. So those issues which previously arose as to who's signing this application and do they qualify to make the application is not relevant to this. So where in the past we've said you don't qualify as a surplus farm dwelling, so you can't make the application. That's not the circumstance here. I'm just clarifying why we had in the past prevented people from proceeding on the basis that they didn't have the capacity to sign it. So just making clear that's not the situation we have here. Secondly, as I said, the planning principles have been followed, the application is correctly made, all the planning provisions have been complied with, simply administrative. I would suspect that the committee would like a confirmation from the owner, the corporation, confirming that at the time of the execution of the application, that Mr. Mitchell was in fact making it on behalf of that corporation. So it would simply be an acknowledgement by the corporation, backing up and providing stronger evidence that yes, when that was signed, it was signed on behalf of the corporation, the owner of the property. Other than that, I have no further comment beyond what Nicholas has just commented on.
Mr. Chairman, is the solution then a condition on the severance, or is it simply a letter?
I would think it would simply be a form that says acknowledgement of authority from corporation to Land Division Committee, setting out particulars that at the time of the application, Mr. Mitchell was signing on behalf of the corporation, and then signed by the authorized corporate officer, and it simply stops up the gap in the ownership. It would not be a receipt of that would be a condition before we stamp it, but to the extent that it's not a separate condition.
Any other questions?
Through you, Mr. Chair. So just to clarify then, what is documented when this consent was given? The consent was given to two individuals on the application, Greg Mitchell and Scott Gilvasi, as applicants. So would it be correct to assume that consent given to those two named individuals, it can't be legally binding, correct? Because they're not legally the owners. So
the consent as it is now could not be transferred to them.
correct.
We have some sort of evidence that the applicant was the correct applicant and therefore corrects the error at the beginning of this whole application process. The only way that you could do it otherwise would be sort of a stopgap measure going around the whole thing, whereby 1120 Properties transfers all these lands to the two people who applied. They now own it. They can proceed. But given the nature of the error, the oversight, I don't know that the committee would necessarily put the applicant through that process. But technically, they could do that, or the committee could allow them to do that. The two people who applied, 1128 transfers the property to them, They bring in the severance deed or the transfer deed to 1128 properties, everything's in compliance. So instead of forcing them to go through that process, I don't believe it's unreasonable to say, yes, the intention was initially for the proper person. He is the actual, Mr. Mitchell is the actual person, sole person who has authority to do so. And we simply need clarification as to why the 1128 didn't appear on the application. And it is not uncommon for individuals who own corporations to act for those corporations without necessarily putting the corporate name on there. As I always said, it's my truck until Revenue Canada says there's a capital gain. Now it's the company's truck.
Yeah, my only concern is down the road that clarified properly so that there's no question down the road that, you know, historically a consent was given to two individuals, yet they didn't rightfully own the land. So whatever you recommend
That's why I'd like,
legally,
that's why I'd like to see something in the file.
yeah,
Explaining why
exactly.
the two applicants, if anyone looked into it years from now, it doesn't look like they own it.
Right.
But in our file, we've got an explanation for that. They didn't own it, but one of them had the authority to act for that corporation and intended to act for the corporation when they made the application. Anyone trying to say, well, if this particular circumstance arose again, hopefully it won't, but if it did arise again, we would have that in the file saying that's what happened in that case.
That's my main concern. Yeah.
So we have something in the file correcting the inadvertent name used in the application.
Brian, you have any comments?
No, I was just going to say, thank you, Mr. Chair. Based on County Senior Counsel's advice and subject to Julie's acceptance as well, the proposed resolution would be that the applicant provide documentary evidence satisfactory to the county solicitor that the owner of 1128 Properties Incorporated made applications, the four applications, 7621, 7721, 7821, and 7921, and that the individuals that initially filed said applications were acting in the capacity as corporate officers. Upon such documentary evidence being received, the Land Division Committee is satisfied and the Secretary Treasurer may provide certification provided all conditions of consent are met.
Dennis?
I'll move that recommendation.
Moved by Dennis, seconded by Rosemary. Question, John?
Just a very straightforward question through you. We are also making the assumption that no particular advantage was given to the applicant by having the application signed the way it was and now changing it afterwards. As far as I can tell, this was just a straightforward mismatch, and there's nothing nefarious here, but presumably that's an assumption we're making, that there was no advantage to the applicants by going this route.
Any comment? Yes, John?
That's what I was referring to in that in this particular case, it doesn't appear to be any nefarious intent. They aren't using someone's name because that person qualifies to make this application.
That's right.
So therefore, I don't see that it is necessarily a situation where we can say, well, someone was attempting to make this application because they qualified to make this type of application, whereas the actual owner did not qualify. I don't see that as a situation in this particular case.
That's great. Thank you, Mr. Chair.
Okay, we have a motion on the floor.
Their lawyer wants to speak.
Yeah, yes, go ahead, sorry. Go ahead.
Sorry, I just have an, through you, Mr. Chair, to Mr. Hogan. Would you prefer that this, regarding the motion that's on the floor, would you prefer that to be an acknowledgement or would you want that in affidavit form?
No harm in making an affidavit. I turn this on. No harm in making an affidavit which is supported by the sworn application, so.
Okay, thank you.
Okay, that's all your questions? All in favor? It's carried.
Thank you.
Thank you very much. Thank you.
All the lawyers going and get some work done now.
Okay,
I don't know what I have to do with it.
okay.
Good enough for me.
The date of our next meeting is April 27th. And any other comments before adjournment?
Just a quick question, update on, I know interviews for planner, or is there going to be an announcement anytime soon?
Julie, do you have a comment, please?
I do, yes. I hope to be able to provide you with an email by the end of today.
Thank you.
That's quickly enough.
Yes, that's very good. Thank you. Yes, Rosemary?
Mr. Chair, we didn't have to confirm our signs. Do we not have to do that anymore?
What I was gonna speak to that on the signs, I think, is we have to look at the signs, but if everything's in place,
Comment?
we don't comment. Is that right, Julie?
That's correct.
They're
Yes,
in
unless
place.
we are advised otherwise by members, we assume that you have undertaken those checks and will rely on the applicant's certification that they have also posted those signs.
Yes, okay. That's gonna, go ahead, Jack.
So further to that, Julie, what's the correct protocol that you would like to see then if we go out 14 days in advance and the signs are not posted? Are we to report that to you
Brian,
or to Brian?
that's,
Either or, yes, thanks.
Then you would contact the applicant to let them know.
Yes.
Thank you.
that's the same way it was before too, Julie, like,
Yep.
they weren't there, we notified
What?
the secretary and then they looked after. Any other comments from anybody? Motion for adjournment by John Andrews. All in favor? Yes.